day, students, and welcome to this facilitation class. I am Dr. Alero Akujobi, your facilitator for this class. This is Criminal Law 2, PUL342, and we are going to look generally at the topics we shall be dealing with under this class. We shall be looking at such topics like offenses against property, under which we shall be looking at stealing, false pretenses, receiving stolen goods, burglary, and so on and so forth. We shall also be looking at the administration of criminal justice in Nigeria. We shall be looking at the various courts. We shall be looking at those things, what are the roles of the courts, what are the functions, and also we shall be looking at the rights of the accused persons, the rights of the victims, and all of that. And we shall also be looking at some sections of the Constitution that also throw some light on some of these issues. And again, the aim is that at the end of the day, we shall see how well or how good our criminal justice system is in Nigeria. We shall also be looking at other topics like the administration against the state, like sedition, defamation, treason, and issues like that, perjury, contempt of court, and all of it. And of course, we shall also be looking at penal theories, talking about the various types of sentencing, dispositional methods, and of course, we shall be looking at things like compensation and restitution and all of that, just to ensure that we have a good grasp of what the criminal justice system is all about. Again, it's a very interesting course, like I said, and along the line, we shall also be talking about the different stakeholders in the system, the police, talking about correctional institutions and things like that. So I enjoy every one of us to be part of it. It's an interesting course, and we'll find out at the end of the day we are better off for it. So welcome on board. Thank you. Hello class, welcome to another day on Criminal Law 342. PUL 342 on criminal law. Again, I'm Dr. Akujobi Alero, your facilitator for this class. Today, we are going to be looking at offenses against property. That is, those offenses that the criminal law sets out to protect the interest, one's interest in such property. Generally, before we will do that, under this topic, which is topic 1, we shall be looking at stealing. We shall also be looking at robbery. We shall be looking at demanding with false menaces. We shall also be looking at burglary and housebreaking. We shall be looking at false representation. Sorry, not false presentation, but false representation or false pretenses. We shall be looking at false pretense, not false presentation. And also, finally, we shall also be looking at receiving stolen goods. So, what is the essence of all these things we shall be looking at on this study is to determine at what extent one is still with property, at what extent can one be deemed to have relinquished property, at what point is one with both ownership and possession. We shall be looking at all of that in the process of this class. So, what is stealing generally? We know that stealing has tremendous importance to human adventure, and this necessitates adequate protection through legal machinery. It is therefore not surprised that undue interference with either possession or ownership is often punishable under our criminal law. So, like rightly noted here, protection is necessary through legal machinery in order to ensure that whoever is found guilty is punishable under our criminal laws. So, stealing generally is a generic term. Generic in the term that most of the other offenses we shall also be looking at have certain things in common. Absence of consent, presence of fraud, and things like that. So we'll find out that this kind of characteristics makes it generic in this sense. So the purpose of stealing general is to promote security of property by threatening aggressors, like I said before, with punishment. By threatening those that are found wanting, the accused persons, with punishment. It can also be seen as a generic term, embracing a wide variety of misconduct when a person is unlawfully deprived of his or her own property, or when one's property is being converted to another one's use. Of course, we can say there that what has happened there is the incident of stealing. Like we said before, whether it again, like I said from the above, we've seen that one of the basic elements that must be in when you are talking about stealing is the issue of fraud. Of course, fraud, the element of fraud will always support a charge of stealing. Once the prosecution can establish fraud on behalf of the accused person, of course, it will be deemed to have stolen the item. Also, conversion. You must also have dealt in the goods in a manner inconsistent with the right of the true owner. That, of course, will amount to conversion. If, for instance, you take a bicycle that you know that the owner normally uses for, or you steal a vehicle that you know that the owner uses for going to work for his family, and convert it to a commercial vehicle, you've dealt with that vehicle in a manner inconsistent with the use of the owner, and you'll be deemed to have converted it because it will be obvious that for it to have amounted to stealing, of course, you didn't take it, you are doing so without the consent of the owner. So, provided, so we are talking about to amount to conversion, we are talking about dealing in goods in a manner inconsistent with the right of the true owner, and then with an intention on the part of the accused person or defendant, in so doing to deprive the owner right or to assert a right which is inconsistent with his own use. So I hope you are following, because you will find out that all of this, what we have said so far, is that to steal means to destroy. It could mean to destroy. It could mean to alter. It could mean to sell. It could mean to pledge or use property belonging to another person. So all of this you will find in section 382, subsection 2, A to F. This is very, very important, because this whole that provision, those A to F provision under subsection 2 of section 382 gives you all the intent. Either the person stealing destroys, either he alters, either he sells, either he pledges, or he is using the property in a manner that is not consistent with that of the owner. So that's about it. Now, the conversion also must be to the use of the accused person or some other persons. So in section 384, subsection 4, in deciding whether a conversion is fraudulent, it is immaterial that the converter had an innocent possession of the property, or that he had a power of attorney for its deposition, or was otherwise authorized to dispose of the property. What are we talking about here? It is immaterial whether you bought in the market, overt, or wherever, and you found those goods in your possession. Once it can be established that those goods have been stolen before that time, of course, the goods could be returned to the proper owner. So what are the subject matter of stealing? Under the common law, like we said, only tangible property could be subject to stealing. Tangible property is property that has physical form and is capable of being torn. It is movable property in the sense that it can be taken and carried away. Personal property, on the other hand, is anything that is of value, that is subject to ownership. And when, for instance, that is not land in the sense that it is not a fixture. You cannot move land like that. So land, of course, is not something that is capable of being stolen. We also have crops and minerals. They are also considered not to be personal property until, of course, they've been severed from the land. And domestic animals are also considered to be tangible personal property. It is important that you understand what is tangible and intangible property, because some questions could be asked and you might not be confused that, oh, you might just be answering the question without knowing that you are writing off point, because the thing you are saying is subject to stealing is not subject to stealing because it is a tangible property. So you have to, first of all, when such questions are given, first of all, understand the subject matter. Is it tangible property? Then, two, you also have to understand whether it is personal or it's not a personal property. So, of course, you could have something like deeds of conveyances being stolen from the registrar of title, as in the case of Ayola. Such can amount to tangible, once it is in that form, it's no longer in the form of land, it can amount to tangible property. Also, the case of Mowe and the state is also of importance. So when you talk of personal property, what are those things we are looking out for? One is that such property, for it to be personal, it must constitute, it must be something that has value. It is something that you can attach value to. So where, for instance, you dump some things in the dustbin and things like that, of course you no longer attach value to such a thing. And if it's been taken, you can't claim that such things have been stolen. In some areas and in some jurisdictions, certain things are forbidden. So when you go there and, for instance, you take them, much importance is not put upon them. So they are not regarded as things that are capable of being stolen. Then we have also the issue of ownership. Such personal property must be property that you can lay ownership to it. Like in R and Vegas, like the case I just said, going to steal abandoned old sheets of iron, from the dustbin or something like that. That of course cannot be deemed to have been a subject matter that has been stolen. So you also have the case of R and Esom. Please, they are all in your textbook. Go back and also read them. And then, of course, we have the case of Honor Gurua and the state, where Justice Nikki Toby of Blessed made the following statement on ownership. I quote as follows. I quote, that ownership is the most vital and indispensable essential or ingredient of the offense of stealing. It is the prop upon which all other essentials or ingredients stand. It is the baseline of the offense of stealing. Because an accused person could be convicted of the offense of stealing, there must be evidence of stealing. The person could be natural or artificial. So you have seen what he has said here. Of course, for you to place value on a property, because you are the one owning that property. So he has made us to understand that ownership is the baseline, is the prop upon which all other ingredients stand. And again, one thing we should understand is that this ingredient must exist. It's different if it is something that's capable of being stolen. It must also be something that has ownership, and of course also be something that has a value. So other cases we can see there is the case of State and Odimayo, and also Oxford and Moses. Then before we go to the last one, we dealt with this one the other time, talking about different types of stealing, which I also have for you there. So just look at it briefly and understand them. What are the different forms of stealing? Stealing by mistake, stealing by finding, stealing by intimidation, and things like that. All for you to understand stealing by trick, all for you to understand the different form of stealing and to be able to place them appropriately. So again, the question I have here is something. We have a question here, which is like what I gave you this question last week, but today I want us to look beyond that. We've been talking about stealing and all of that. Question I have here is discuss the intent under section 382 A to F of the Criminal Code relating to stealing with the aid of cases. I said discuss the intent under section 382 A to F of the Criminal Code relating to stealing with the aid of cases. So I expect you to go to 382 or 382 of the Penal Code, subsection 2, subsections A to F of the Criminal Code, and also 286 of the Penal Code on stealing, in order to understand the intent, to understand the cases that have been provided for there, and the sections under which the different types, either by pledging, either by destruction, either by conversion in a manner consistent with the use of the owner, and things like that, in order to understand and be able to place each one appropriately. Then finally, I want you to also go and explain the difference between robbery and stealing. There are some differences. When people say robbery is stealing, some is not stealing, it's armed robbery and all of that. What is it? So you should be able to tell me the differences when we meet next class. So I want to thank you for your time once again for today, and we hope to meet another time. Thank you.